Welcome to EPG Pathshala. This paper is the philosophy of law. The current module is entitled Political Meanings of Shariat in Post-Colonial India. The objectives of this module are to understand the nature of the Shariat and how it emerges in political discourses in the post-colonial period. The module was written by Hilal Ahmed of CSDS. I am Akash Singh Rathore from Lewis University in Rome. Now, when we talk about the political meaning of Shariat in post-colonial India, there are numerous aspects that we have to consider. So we're not talking about the Sharia as such. This is not a history of Sharia law. This module is context specific to the Indian context, because the nature and scope of Sharia, of course, differs from place to place in different kinds of Muslim countries and different in respect to whether the Muslim is majority community or a minority community, as is the case in India. So that's to be kept in mind when we discuss the political meanings of Sharia in post-colonial India. We're speaking specifically of how it has emerged in India. Next, we have to understand that we're talking about the political meanings of Sharia, not the necessarily exclusively legal content of it or the theological meaning of it by any means, although both of these aspects are going to be touched upon in this module. So then we've discussed the political meanings of Sharia in post-colonial India. So now let's concentrate on the final term that we have to clarify, which is post-colonial. So obviously the nature and evolution of Sharia law is a very complex and fascinating subject. We're limiting ourselves in this module primarily to the post-colonial context because we're trying to understand the current nature, the current situation of the way that Sharia is understood and the political uses and arguments surrounding Sharia in contemporary times. Now, one of the clearest examples of both the fact and importance of this is in the recent Shah Bano controversy. Now, this particular case that went all the way up to the Supreme Court has, of course, been the standard or standby for the discussions of the meaning and the scope of Sharia and for the push or resistance to the uniform civil code in India. So as everybody knows very well, the legal system in India is quite plural, and the civil code is itself plural, and there's a great deal of especially majoritarian but also some minoritarian push for the uniformity of that code. There is also a great deal of resistance, and much of the battle lines are drawn with respect to the configuration of the meaning of Sharia. So in this module, we're discussing the political meaning of Sharia in post-colonial India, and now you will have understood the meaning and the significance of each of these terms. So let's begin to look at what we mean by the political meaning and see how these arguments about Sharia get politically charged. We're going to look at them with two more or less underlying questions, or let's say orientations. The first is the way that the minority uses the constitutional rights, the constitutional guarantees, to generate certain political traction. And the second thing that we want to keep our eye on is, of course, the way in which what we refer to as Sharia gets various meanings based on the political inflections that are attributed or that are being played around with or debated or argued. So the module is going to always have its eye on these two sorts of aspects, and we'll want to keep that in mind and come back to what we have learned in the conclusion. So now let's get into the first part of the module. So what is the Shariat historically? According to the All India Muslim Personal Law Board, that's AIMPLB, this is what they have to say. Qanun-e-Shariat is a collection of rules and norms that have been codified following the intentions and consent of Almighty Allah as expressed in the Holy Quran for making human life meaningful, peaceful, and successful. Any act of law making in the name of Islam must follow the orders and directions given by Allah. Following these principles, our ancestors performed the sacred duty of Tashri' Islam, explanation of Islam, which is also known as fiqh and usul al-fiqh. A Jamaat of Fuqaha ulema was born after the Prophet Muhammad by the mercy and generosity of Almighty Allah for this task. As Allah says in the Quran, why cannot a section of people from all groups go ahead for exploring interpretation of deen? Allah entrusted the responsibility of explanation of divine laws to Fuqaha. Consequently, the assembly of Fuqaha was able to produce a body of law which covers all aspects of human life. The Fuqaha never deviated from the divine will and its virtual obedience. That is because their explanation was entirely based on wahi-i-ilahi. So this was translated from Urdu, and it gives a profound and all-encompassing sense of what is meant and attributed to Qanun-e-Sharia. Well, notice that the interpretation of Shariat has three interesting aspects. One, the Quran is the fundamental source, which cannot be changed and which is relevant for all human societies. Since the guidance or legal indications given in the Quran are not entirely spelt out, the legality of Quran verses is subject to certain controlled elaborations. Now, the second point, the Sunnah or the life of the Prophet is an important reference point in this regard because his life history embodies the legal indications of the Quran. And the third point we want to notice is that the Fuqaha or the ulema class is entitled to reinterpret the Quran, partly because the existence of this class is recognized by Allah in the Quran, and partly because this class continues to adhere to the true message of the Quran or the true message of the Prophet. Well, obviously, the third aspect of this interpretation of Shariat needs some more elaboration because it's related to the complex and provocative idea of human intervention in the unpolluted, indivisible, indissoluble, divine words and practices. The intervention of the Fuqaha class, we must note, is legitimate because of its trustworthiness towards the authenticity of the Quran and Sunnah. This explanation raises a few relevant issues. What is the origin of the Quran and Sunnah? Is this origin self-evident? And if yes, why do we need an interpretation? If we look at the Hadith literature, we find that the compilation of the Quran has a very interesting story. The Quran during the time of the Prophet was not available in the form of a book. The Prophet's companions would memorize the revelations word by word. Salat or prayers 5 times a day was the main ritual in early Islamic society for the recitation of these words. However, after the death of the Prophet, attempts were made to bring together these sacred words so that a basic text of Islam based on God's revelations could be prepared. Accordingly, 114 chapters or surahs were arranged and the principles of recitation of this text were clearly laid down. Interestingly, the verses were not arranged in a chronological sequence. Rather, a different criterion of relevance was adopted. Thus, the Quran, in its present form, is neither related to the history of Islamic struggle during the time of the Prophet, nor does it reflect the sequence or order in which revelations were sent to the Prophet. In fact, we have a compiled and edited version of the Quran. This compilation of the Quran over the course of time transformed it into a relic or an intentional monument of some kind. Its authenticity, that is, of the words of the revelation as well as the order of the verses given to it by the early Islamic religious political elite, consequently emerged as the most essential commemorative value. The religious elite of the subsequent generations evoked this commemorative value, especially in terms of authenticity, to produce various interpretations of the Quran. The rise of the Tasfil ul-Quran, explanation of Quran, literature in early Islamic history is an illustrative example. AIM-PLB, however, offers us another more context-oriented historical account. So let's look at what the AIM-PLB says. After the demise of Muslim rule in India, efforts had been made for the protection of Muslim personal laws in India. The Shariat Application Act in 1937 was the obvious outcome of this endeavor. So what do we notice about this? The passing reference to Muslim rule in India is crucial not only for the deconstruction of the linear genealogy of the ulema class, but also to underline the gradual evolution of the modern notion of shariat. The recent works on Indian Islam, particularly the writings of Muzaffar Alam, Sunil Kumar, and Richard Eaton, problematize the given historical imaginations of Muslim rule in medieval India. They argue that although a large part of the subcontinent was ruled by Muslim kings and rulers, the management of political affairs was not entirely based on the set of rules and interpretations called Sharia. These historical explanations make two more broad points. First, the set of norms called Shariat was contingent upon the context in which a certain version of religiosity came to be recognized as Islam. And the second point, the relationship between this discursively constituted Shariat and actual political discourse was highly fragile and unclear. Precisely because of these two possibilities, locally evolved cultural practices emerged as the main source of Islamic religiosity in pre-British India. Interestingly, many of these practices later became customary laws, which were intentionally separated from personal laws. Two very significant developments in 19th century North India, which are the translation of the Quran in Persian and later in Urdu, and the circulation of the tafsir literature, established a clear distinction between Shariat-based ideal Islam and the customary practices associated with various Muslim communities. Muslim reformers, particularly the ulema, constructed a highly idealized picture of classical Islam and started marking the actual cultural practices as un-Islamic. In fact, the term ghayr shariat was established as an explanatory category in religious texts. Since the Shariat-based Islam had already been recognized by the colonial state, following a secularism of strict neutrality, Mark Galanter has argued that customary practices lost their potential as a source of law. So, in 1913, the Waqf al-Ulad Act and the Muslim Personal Law Shariat Application Act of 1937 evolved quite directly out of this legal scheme. So what we see then, what we're understanding happening here is that the struggles of the ulema, which the All India Muslim Personal Law Board's version of history talks about, also revolved around the protection of the various versions of this Shariat-based ideal Islam. Well, let's move on to the post-colonial period then and understand the post-colonial Sharia. The legal constitutional justification of Shariat in post-colonial India is based on two strong hypotheses. First, the right to religion can also be interpreted as a right to have personal law. And second, Shariat is an essential aspect of Islam as a religion. Let's locate these conclusions in the context of the 1940s. Creation of Pakistan somehow made it difficult for the Congress Muslims to make a strong case for Shariat laws. They had to face two types of challenges. The partition of India based on religion encouraged Hindu rightists to demand that India should be a declared Hindu state. From this point of view, the demand to have separate personal laws was a reflection of intolerable Muslim separatism. On the other hand, there was a strong modernist secular lobby within the Congress which became proactive in pursuing a radical social reform agenda. For this lobby, Muslim demand was a sign of an inward-looking attitude. Despite facing these adverse political forces, the Muslim members in the Constituent Assembly managed to raise the question of Shariat in the debate on personal laws. The outcome of this debate was quite delicate. The personal laws were recognized along with other customary laws, while at the same time, the supremacy of the constitutional law was upheld. So we can look at what Ambedkar says about this. I'll quote from him in the Constituent Assembly debates, 24 November 1948. "There is nothing extraordinary in saying that we ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. We must all remember, including members of the Muslim community who have spoken on the subject, though one can appreciate their feelings very well, their sovereignty is always limited, no matter even if you assert that it is unlimited, because sovereignty is the exercise of that power and to reconcile itself to the sentiments of different communities. The government can exercise its power in such a manner as to provoke the Muslim community to rise in rebellion. I think it would be mad government if it did so, but this is a matter that relates to the exercise of the power and not to the power itself." Ambedkar's clarification in a broader sense points towards the classical distinction between the state and the government. The Constitution, Ambedkar seems to suggest, is a symbolic embodiment of the idea of the sovereign state. The government, in this classical liberal formulation, is the actual governing body whose decisions are entirely contingent upon the contextual wisdom. Thus, the supremacy of the state, in this case, in Ambedkar's case, the Constitution, cannot be challenged by any community because it represents a collective whole. And yet, the limits to have certain community-specific rights are to be decided by the government. The meaning of religion given in Article 25 is quite comprehensive. For instance, the term religious affairs covers a variety of activities, including the management of functional religious places of worship, as well as various acts of religious nature associated with them. The Indian judiciary, however, has devised an interesting concept of essential practices of religion to determine the limitations of religious institutions and the secular control of the state. The Supreme Court in various cases has observed that there is an essential part of religion that constitutes the core or the center of the entire belief system. According to the Supreme Court, this essential part of religion has to be protected, and the state can intervene in other non-essential religious activities. The difference between essential religious practices and non-essential religious practices may be understood as a workable legal formula. However, it raises an important question. How could a secular judiciary based on rational principles determine the essential practices and non-essential practices of a religion? Or what could be the principles by which certain practices might be designated as essential practices? This point was raised by many scholars at the time of the Shah Bano controversy. For instance, in an article published just after the Supreme Court decision in 1985, Tahir Mahmood argues, and I'm going to quote from Mahmood, "Of course, the fault does not lie with the court. The Quran, like the Holy Vedas and the Bible, is a revealed book. Would any modern court anywhere in the world attempt to interpret the Rig Veda or the Old Testament? Laws derived from the Quran in the distant past are found in the books of law, and the court could definitely have interpreted those books. Reinterpreting the Quran itself straight away was, however, not a task that the Supreme Court of India or any of its judges should have performed." If we accept Mahmood's persuasive argument that the Supreme Court's decision might have been in accordance with the provisions of the CPC, Criminal Procedure Code, or with the judge's conception of equality and justice, but it was not in conformity with traditional Muslim law, one might ask a straightforward question. If the Supreme Court does not have the right to interpret the Quran directly, what is the logic behind accepting the supremacy of the Constitution or Supreme Court as the protector of minority rights? After all, shariat is always presented as a complete way of life, which also covers the criminal cases in which Muslims are involved. In other words, why is there a controlled demand for the protection of a personal law that is only concerned with civil issues? The question was also raised by Law Minister Ashok Sen in a parliamentary debate on a private bill presented in April 1985 on deleting Article 44 in the Lok Sabha. So Let's look at a quotation from Muslim India, May 1985. An argument has been advanced that when the Indian law of crimes, which is also at variance with the Islamic law, then why an objection is taken with respect to personal law? I submit that this is perverted logic. If a part is not made available, it doesn't mean that the other should be surrendered. Let me declare that we, the Muslims, are prepared to submit ourselves to the law of crimes as envisaged by Islam if the state is prepared to enforce it upon us. I emphasize the word free, which has been used deliberately and purposely in Article 25 of the Constitution of India. Free practice means when your own religion gives you certain discretion, you will be free to make your own choice. Closing the doors of discretion for an individual is not free practice of religion as contemplated by Article 25 of the Constitution. I must appreciate the position taken by the government. It has been made amply clear that there is no intention on the part of the government to bring about any changes in the personal law of the Muslims unless and until the Muslims themselves desire it. This reply, quite obviously, overstates the case of freedom of religion by making a rather technical explanation. Yet the distinction that Ambedkar makes between the state and the government is evoked to articulate a theoretically nuanced and legally plausible position. It is claimed that the state, in principle, recognizes the interests of the community. In conformity to this recognition, the community also recognizes the state as an ultimate protector of rights. The government has to admit this mutual trust in devising various laws. Now, in a recent judgment on the legality of Islamic fatwa and the existence of the Muslim Personal Law Board, the Supreme Court made an interesting observation. The court had to decide whether the AIM-PLB strives for the establishment of a parallel judicial system in India. According to the judges, and now I'm going to cite from the Indian Supreme Court, one may not object to issuance of a fatwa on a religious issue or any other issue, so long as it does not infringe upon the rights of individuals guaranteed under law. Fatwa may be issued in respect of issues concerning the community at large, at the instance of a stranger. But if a fatwa is sought by a complete stranger on an issue not concerning the community at large, but an individual, then nobody may consider the desirability of giving any response, and while considering it should not be completely unmindful of the motivation behind the fatwa. Issuance of fatwa on rights, status, and obligation of individual Muslim, in our opinion, would not be permissible unless asked for by the person concerned or in case of incapacity by the person interested. So we've discussed this module on the political meaning of shariat in post-colonial India by concentrating on a very interesting interpretation that is presented by the All India Muslim Personal Law Board. So what we found is that we can discuss the nature and history of shariat in relation to the unique nature and history of the rise of the Quran, Sunnah, and what we mean by the Sharia law. But none of that is completely universally important. What makes far more impact on the nature and meaning of shariat is the specific context within which the shariat is correlated to some idealized version of Islam. Now, the emergence of the significance of the shariat then is shown to be, by the argument presented in this module, deeply connected with certain historical contingencies. So, one of those contingencies is, of course, the way that the Quran became interpreted in South Asia. As the module pointed out, one of the major events of the alteration or evolution of that was with the appearance of the Urdu translation of the Quran, and of course the Persian translation. So what turns out to be important is the way that the Quran gets interpreted within the South Asian context. The most determinative aspect in the interpretation of the Quran is, of course, the emergence of the translations of it in the subcontinent. So the Urdu translation, which is the most important, and the Persian translation, which is also important to some extent. But of primary import is, of course, the Urdu translation. A second way in which the specific evolution of the understanding of the political meaning of shariat is contextualized is the way in which the idealization or necessity of maintaining the shariat is correlated to an era of Muslim rule in India. So, as the author of the module pointed out, the All India Muslim Personal Law Board, when explaining the significance of shariat, points out or doesn't fail to mention that it emerges in the context of Muslim rule in India. And this is very fascinating because the post-colonial meaning or significance of shariat is very largely constructed in relation to Muslims as a minority. So the minoritarian aspect of post-colonial shariat is strangely inflected by the insistence of recognizing the significance of shariat and fixing it to a historical era of Muslim rule. So we've mentioned the interpretation of the Quran and the translation into Urdu. We've mentioned the linking of the understanding of shariat to Muslim rule. And the third aspect is, of course, the debates that occurred with respect to personal law and how the shariat can be retained in post-independence Indian legal system as personal law in relation to the emergence of Pakistan. Because during the time, if Pakistan is going to be a explicitly Muslim country, India has the option not being explicitly secular, but it can also orient its legal system towards the religious minority, which was, of course, the Hindus. So in a context where there are a number of conservatives who wish to counterpoise a Hindu India to Muslim Pakistan, it was the task of the Muslims in the Constituent Assembly to negotiate the possibility for articulating the need or demand for shariat within appearing as personal law within the new legal system of a post-independent India. So this is a very delicate balance. In these three very peculiar historical circumstances, we see that the nature of shariat is problematized as being something perfectly universal. What shariat is not merely the articulation of religious law for Muslims, because what a Muslim is very radically determined by the geographical and historical context, as this module has shown. So what we focused on is the political meaning of shariat in post-colonial India, to attempt to disentangle, in some respects, these arguments about what the Sharia dictates or commands as being absolutely necessary in a particular case. Obviously, when you present the shariat in its historical evolution as fixed to some ideal and historical conception of Islam, you know that what that concept of sharia would dictate in any particular instance has to be as fluid and flexible and open to negotiation as the very concept itself. Shah Bano case, as we mentioned, was one of the most paradigmatic instances of where these historical and theological issues clashed. And the case remains one of the most important cases in the philosophy of law in India. So that is the way in which shariat affects the understanding of the philosophy of law, which was the concentration in this module. Thank you.